Okay, imagine this. You spend years and, frankly, a ton of money on an arbitration process. You finally get the award, but you notice there's one small, fixable mistake in it. So what happens now? For years, this has been a massive headache in Indian law. Does the court have to throw the whole thing out and force you to start over? Or can it just, fix the error? Well, let's dive into how a landmark Supreme Court verdict just gave us a brand new answer.
To really get what's at stake here, think about it like this. You order a custom-made suit. It's almost perfect, fits like a glove, but one button is just a little bit off. What's the logical thing to do? You'd ask the tailor to fix the button, right? Of course. You wouldn't demand they burn the entire suit and start from scratch. That would be insane. And that is precisely the dilemma courts have been facing with arbitral awards.
And this slide, well, it lays out the legal battlefield perfectly. On one side, you have the nuclear option. Set aside the award. This just kills the whole thing, sends everyone back to square one after years of effort. On the other side, you've got the common sense approach. Modify the error, a practical fix that saves everybody time and money. But the big looming question was always, did the courts even have the legal authority to do that?
To really understand how we got this new answer, we have to look at the two key pieces of law that were at the heart of this conflict. And trust me, it's a tale of two very different legal provisions basically pulling in opposite directions. So first up, we have the Arbitration and Conciliation Act of 1996. Now, the entire philosophy behind this law is speed, finality, and this is the most important part, minimal court interference. And Section 34 is the key here. It explicitly gives courts the power to set aside a flawed award. Now, notice that very specific wording, set aside. It doesn't say modify, it doesn't say correct or vary. It's a very specific and kind of rigid power.
But then you've got the constitutional wildcard, Article 142. This is this incredible sweeping power that's available only to the Supreme Court. It basically allows it to pass any order it deems necessary to do complete justice. It's there to make sure that rigid legal rules don't get in the way of a fair result. So you can really see the tension here, can't you? You've got a specific act that says set aside and a constitutional power that says do complete justice. Something had to give.
And look, this isn't just some dusty, theoretical power that's never used. As this chart shows so clearly, the Supreme Court has been relying on Article 142 more and more over the decades. It's become a really vital tool in its arsenal, which made a clash with the restrictive language of the Arbitration Act pretty much inevitable.
So this legal pressure cooker finally exploded in the case of Gayatri Balasamy versus ISG Navasoft. Let's step inside the courtroom and check out the arguments that would literally redefine Indian arbitration law.
Inside the courtroom, you could really feel the stakes. One of the lawyers put it so powerfully, setting aside is the death of the award. That is the last remedy. Wow. I mean, that really frames it, doesn't it? It's not just some legal procedure, it's a destructive final act that completely undoes years and years of work.
But the counter-argument was all about being pragmatic, being flexible. The court was urged to see that set aside shouldn't just be a black or white, all-or-nothing choice. The argument was, listen, if you have the massive power to destroy the entire award, it has to logically include the lesser power to just set aside a small flawed part of it. In other words, to modify it.
This brings up a really crucial point, though. How could a court modify an award without acting like a court of appeal and stepping on the arbitrator's toes? Well, the solution proposed was genius. Limit this power only to cases of patent illegality. Errors that are so obvious right there on the face of the award that fixing them doesn't require reweighing any of the evidence. The court wouldn't be second-guessing the arbitrator, it would just be correcting a clear, undeniable mistake.
And all of this circles back to the whole point of arbitration in the first place. As the court heard, the goal is to make arbitration a vibrant alternative force, to avoid the protracted litigation it was designed to replace. And if every tiny flaw sends people right back to the beginning, then the whole system just doesn't work. So, after hearing all these compelling arguments, the Supreme Court was ready to deliver its judgment. And believe me, this was a decision that was going to send ripples through every arbitration in the country. And here it is, the moment we've been waiting for, the verdict. In a truly landmark ruling delivered this April, the Supreme Court came down and said, yes, courts can in fact modify an arbitral award under Section 34. It was a huge win for common sense and pragmatism over rigid, literal interpretation. But, and this is a big but, this new power isn't a free-for-all. The court put up some very clear guardrails with a three-part test. First, the error has to be a patent illegality. super obvious, not something you have to debate. Second, fixing it can't require the court to reevaluate the evidence. And third, the flawed part has to be severable, meaning you can surgically remove and correct it without messing up the rest of the valid award.
So, what does this all mean in the real world?
Why is this such a big deal?
Well, this isn't just some minor legal tweak. It's truly being hailed as the dawn of a new, more practical era for arbitration in India.
I mean, the impact is absolutely massive. We're talking about a huge boost in efficiency and some serious cost savings for businesses. It's a clear signal from the courts that they're shifting towards practical, outcome-focused justice. It gives everyone clearer rules, which reduces confusion. And really, the bottom line is this: it strengthens the entire arbitration system, making it a much more attractive and reliable way to solve disputes.
But this all leaves us with one final, very important question to think about. By giving courts the power to fix the button instead of burning the whole suit, has the Supreme Court struck the perfect balance, or has it accidentally opened up a new can of worms where parties will now just argue endlessly over what counts as a fixable error? That right there is the question that's going to define the next chapter of Indian arbitration.